before we get there, so perhaps that will be enough time for her to log in and get her issues sorted. So I will start the meeting then. I call this meeting to order. Welcome to meeting number 32 of the House of Commons Standing Committee on Justice and Human Rights. Today we have MP Stéphane Lauzon, who's replacing MP Randeep Sarai. Welcome, bonjour, bienvenue, Stéphane.
You're welcome, Stéphane. It's nice to see you.
So to ensure an orderly meeting, I'll just outline a few of the rules. Interpretation services are available to you. Just click on the globe icon at the bottom of your Zoom. You should select the language that you would like to listen to. You can speak any of our 2 official languages, and interpretation will pick it up. Before speaking, please wait until I recognize you by name. If you're, everybody's on the video conference, just make sure that your microphone is unmuted before you speak. And once you're done speaking, just make sure that you are back on mute. And a reminder that all comments by members and witnesses should be addressed through the chair. With regard to the speaking list, Mr. Clerk and I will do our best to ensure an orderly list of speakers when you're participating and you'd like to speak. Now, before we go to our study on elder abuse, we do have to approve the report from the subcommittee meeting of Tuesday. So the report was distributed to members electronically yesterday. If there are no comments on it, do I have agreement of members to carry this report? I see thumbs up from everyone. Wonderful. Thank you very much. And now just very quickly, in the subcommittee meeting, members will recall that Mr. Clerk had undertaken to inquire about the status of translation delays for our committee documents. So maybe I'll turn it over to Mr. Clerk to give us an update on that.
Well, thank you, Madam Chair. Here's what I found out. The Translation Bureau now is currently operating at full capacity and has tried to get as much help as possible internally and externally. Unfortunately, it has not been able to always fulfill the usual translation delays lately. So at this point, additional delays may be expected depending on the context of our translation request, like for instance, the complexity of the briefs that the committee is receiving, their format, and so on and so on. Good news is that the House of Commons, the Senate, and the Library of Parliament are meeting weekly with the Bureau to talk about translation priorities arising from committee activities. So as your clerk, I will make sure that if the need arises during the upcoming weeks, prior to the summer recess, our priorities will be communicated at this weekly meeting. Thank you very much, Madam Chair.
Thank you, Mr. Clerk. I appreciate that update. Do any members have any questions or comments? Please address them to myself and Mr. Clerk via email, or I'll be in touch with you as well if you do need to speak on this further. So I would like to now welcome our witnesses from the Department of Employment and Social Development. We have Kristen Underwood. Mr. Garrison, is that on the previous topic?
It's on the topic of our agenda for today, and yeah. I just have a question that when we're starting a new study, we normally hear from ministers, and I believe we issued an invitation to the Minister from Seniors, and I'm just curious about the scheduling of ministers to appear before the committee, because when we embark on a study, it's important for us to know what initiatives the government is planning and has underway so we can give a context to the study we're doing. So I am disappointed that we do not have the Minister for Seniors here today at the beginning of this important study, and I just wondered whether we have any indication whether the Minister does in fact intend to appear before the committee.
Thanks for that, Mr. Garrison. I will look into it with Mr. Clerk, and we'll get back to you with an update if that's okay. So with the Department of Employment and Social Development, we have Kristen Underwood, Director General, Seniors and Pensions Policy Secretariat. We also have Susan McPhee, Acting Director General, Social Innovation and Community Development, Income Security and Social Development Branch. And from the Department of Justice, we have Carol Moranci, who's the Director General and Senior General Counsel, Criminal Law Policy Section in the Policy Sector. And we have Joanne Kleinberg, who is the Acting General Counsel, Criminal Law Policy Section in the Policy Sector. Now, I understand Ms. Moranci has made it, which is wonderful. So we'll go into our opening statements from the two departments. Just for your, just take note that I have this 1 minute remaining card and this 30-second remaining card that'll help you keep track of your time. Both of you have 5 minutes to make your opening statements. We'll start with the Department of Employment and Social Development. Please go ahead, you have 5 minutes.
Morning, Madam Chair. Just want to make sure that you can hear me clearly.
Yes.
Terrific. All right, Madam Chair, committee members, I want to thank you very much for the opportunity today to meet with you as you begin your study on elder abuse. Seeming like we're up first, so that's great to start with us. So it's a pleasure to be here virtually on behalf of Employment and Social Development Canada. As noted, I'm joined today by my colleague Susan McPhee from the New Horizons for Seniors program. Seniors are an important part of our social fabric and contribute to the rich diversity of Canada. And that's why the government is committed to seeking widespread stakeholder views on seniors issues so that older Canadians can age with dignity while experiencing the best health possible and social and economic security. Elder abuse is an important human rights issue, as well as a social and public health issue that can undermine a person's quality of life, autonomy, dignity, and sense of security. Both men and women are living longer and healthier lives than before and are projected to live even longer into the future. Seniors are the fastest growing demographic in Canada. In 2020, 18% of Canadians were 65 years of age or older, and it's projected by the end of the 2030s, close to 1/4 of Canadians will be 65 years of age or older. We recognize that elder abuse is a serious issue affecting many older people in Canada, and even more so in the context of the COVID-19 pandemic, which has contributed to further isolating seniors. Physical distancing around the COVID-19 pandemic has put seniors at increased risk of abuse since so many seniors are living in isolation and do not have access to their usual community supports and social connections. The COVID-19 pandemic has also highlighted systematic, long-standing challenges in our long-term care system. We're deeply saddened and disappointed by the significant and disproportionate toll that COVID-19 is having on seniors living in long-term care homes and other congregate living settings. The Government of Canada values the many contributions made by seniors to our nation, and that's why the government's working to implement measures to help improve the lives of seniors and their families. Each year, the government provides $70 million in funding through the New Horizons for Seniors program, NHSP, to seniors serving organizations across Canada. While one of the 5 objectives of the NHSP is to raise awareness of elder abuse, the overarching goal of the program is to increase the social inclusion of seniors. By increasing the social inclusion of seniors in communities, this can help us to reduce the prevalence of elder abuse as seniors face a greater risk of abuse when isolated. Funded organizations aim to address key issues facing seniors, such as elder abuse, through projects that raise awareness of elder abuse, connect seniors with others in their community, and provide navigational support to help seniors find community resources and services that they need. Elder abuse can take on several different forms, such as neglect, physical, psychological, or financial abuse. These can have negative effects on older adults and their families. One of the most frequently identified types of elder abuse is financial abuse. And that's why the National Seniors Council, as part of their 3-year work plan from 2018 to 2021, examined and identified measures to reduce crimes and harms against seniors. To support this work, the National Seniors Council hosted an expert roundtable and a town hall to identify promising practices and discuss new measures to reduce financial crimes and harms against seniors. In August 2019, the National Seniors Council published a What We Heard report based on their roundtables. It found that while the Government of Canada has a leadership role to play in establishing and maintaining policies, programs, and services that support seniors, other levels of government, community organizations, and the private sector are all vital partners in addressing financial crimes and harms perpetrated against seniors. The government is committed to raising awareness about fraud and scam-related activities. It does this through a number of mechanisms, including news releases, social media posts, and the Minister of Seniors newsletter. In the past year alone, the newsletter, which engages close to 10,000 seniors and stakeholders across Canada, has covered themes such as fraud and scams. The government's committed to strengthening the approach to elder abuse. In the recent mandate letters of the Minister of Seniors and Justice and Attorney General of Canada, they stated that we will work together to strengthen Canada's approach to elder abuse, including to create a national definition of elder abuse, invest in better data collection and law enforcement related to elder abuse, and establish new penalties and in the criminal code. This was also reiterated in the speech from the throne. Through all these measures, the government is seeking to improve the safety and security of seniors so that they can age with dignity in the best possible health. Of course, there's much more to be done. The government looks forward to continuing to work with stakeholders to support Canada's seniors of today and tomorrow. Madam Chair, honored committee chair members, I trust that your report will contribute to combating elder abuse and will support the Government of Canada in future policy actions in this area. Thanks very much.
Thank you very much, Ms. Underwood. We'll now go to the Department of Justice. For 5 minutes, go ahead, Madame Morancy.
Morning. Nous sommes heureuses d'être ici aujourd'hui.
We are pleased to be here today to discuss the criminal law's responses to senior abuse and negligent and related efforts by the Department of Justice. Senior abuse and neglect is an issue of concern not only for the criminal justice system, but also for other sectors, including the health sector. It's also an issue for the federal and provincial territorial governments.
Provinciaux et territoriaux. As the committee knows, the responsibility for Canada's criminal justice system is shared. The federal government is responsible for the criminal law and procedure, and the provinces and territories are principally responsible for the administration of justice, including policing, prosecution, and the provision of services and assistance to victims of crime. The delivery of health services and long-term care are also matters under provincial and territorial jurisdiction. Each of the provinces and territories has a unique approach to addressing senior abuse, such as through laws that address the abuse of vulnerable adults. At the federal level, the Criminal Code protects seniors against abuse and neglect through numerous offenses of general application. It contains a comprehensive set of offenses prohibiting various forms of assault, including threats of harm and sexual assault, as well as negligence-based offenses that prohibit failing to provide necessary care to seniors or providing necessary care but in a significantly deficient manner. The Criminal Code also contains a comprehensive set of financial crimes which captures financially motivated crimes specifically targeting seniors. These crimes include theft and fraud, which have very broad application and include specific forms of wrongdoing like theft by a person holding a power of attorney. There are also crimes involving a combination of violence or threats and property taking, such as extortion and robbery. The Criminal Code further contains sentencing measures that may be applicable where a senior is criminally victimized. For instance, under Section 718.2, the following are deemed to be aggravating for sentencing purposes, where the offense was motivated by bias, prejudice, or hate based on age, among other factors, where the offender abused a position of trust or authority in relation to the victim, and where the offense had a significant impact on the victim, considering their age and other personal circumstances, including their health and financial situation. With respect to certain fraud-related offenses, the Criminal Code also lists additional offense-specific aggravating factors, including where the fraud involved a large number of victims and had a significant impact on the victim, given their personal circumstances, which includes their age, health, and financial situation. These aggravating factors would apply, for instance, in the context of a large-scale financial fraud that targets seniors. Recently enacted Section 718.04 of the Criminal Code also directs the courts to give primary consideration to the objectives of denunciation and deterrence for any offense involving the abuse of a person who is vulnerable because of personal circumstances, and this includes vulnerability due to age. Courts consistently treat senior abuse as an aggravating factor in cases involving criminal negligence, assault, and fraud. Justice Canada is also addressing senior abuse through program and policy-related initiatives. The Victims Fund, for example, is available to provincial and territorial governments and non-governmental organizations to support projects that address the needs of victims, including senior victims. and recently made the amount of $1 million available for the development of updating of public legal education and information materials to support victims of senior abuse and neglect. Our Research and Statistics Division is also working with Statistics Canada and others to study the feasibility and leading a study to explore the feasibility and the challenges of addressing national data gaps in senior abuse, including in reporting senior abuse in long-term care. We expect that report to be available in 2022. Je suis heureuse d'avoir l'occasion d'informer le comité.
I appreciate the opportunity to inform the committee about ongoing activities within the Department of Justice on the issue of senior abuse and neglect. Thank you.
Thank you very much, Madame Morancy. We'll now go into our first round of questions for 6 minutes each, starting with Mr. Moore. Go ahead.
Okay, thank you, Madam Chair, and thank you to all of our witnesses for being here today to start off our committee study on what is a very important subject, but has become even more important over the last year and more visible. In the criminal code, there are general offenses for assault, for fraud, and emotional abuse like threats. And in the Protecting Canada Seniors Act that was introduced by the former Conservative government, of which I was a part, it implemented further protections for seniors by establishing sentencing principles that take into account age, health, and financial situations of the victims. Maybe Mrs. Morancy, if you could expand a bit more on how defining elder abuse in the criminal code could build upon that act and establish further protections for seniors. I think this is something that we all care deeply about, but we want to make sure any actions we take will have a positive outcome.
Sure, thank you for the question. As was noted, the criminal code was amended in 2012 to add that aggravating factor. And one of the challenges that was discussed by Parliament at the time was how to define senior. And certainly that was the interest at the time was to ensure that offenses that targeted persons that in that category would be treated more seriously by the criminal law. And as Parliament considered that bill, the way that it was actually enacted at the end landed on, it was as introduced, but it landed on basically the person's vulnerability can be determined by a number of factors. Chronological age is an important factor, to be sure, and that's one of the points that's listed in that factor. But it could also be a combination of other things, such as their health and their personal financial or other circumstances. So the aggravating factor as enacted in 2012 said to sentencing courts, look at all of those things together. A person who is 60, but combined with poor health and vulnerable for other circumstances could be just as vulnerable as a person who is, let's say, chronologically older, 85, other conditions. Mm-hmm. So that's how it was enacted. And I can say that when we look at court reported case law, the courts absolutely are giving specific attention to these factors. They do look at it as a form of general and specific deterrence, and they do look at the combined personal circumstances of the victim to determine whether or not that person was vulnerable because of those factors, as well as whether there was a relationship of trust or dependency between the victim and the offender.
Okay, thank you. You had mentioned the financial offenses, and I think that that is becoming so prevalent. And if members are like myself in our offices, we hear heartbreaking stories from seniors, oftentimes about being targeted for financial offenses. I know we're all aware of the, I had a call the other night from someone saying I needed to press 1 because there was some kind of major problem and I just had to enter my social insurance number. I mean, this is happening on a regular basis, and it's happening And the reason it happens is because somebody is pressing one. Like a lot of us will just hang up now when we get those calls, but enough people are pressing one that seniors continue to be targeted, and others. But I'm talking more about offenses that take place from people that know personally the individual, people that are becoming in a position to of trust. Can you speak a bit to that? Some of the typical type of financial crimes that are committed against seniors?
I can answer that question. Thank you. I think that the offenses of theft and fraud, which Carol, Ms. Moranci mentioned in her opening statements, are quite broadly drafted and apply to a wide range of circumstances, because there are various ways in which people can obtain the financial and other sorts of economic resources of victims. Theft in principle is the idea of obtaining through taking without having authority to take. And fraud in principle can really be thought of as persuading through some form of trickery or deception the victim to give you their property in circumstances that are just marked by dishonesty in some way. So the particular modalities of the way these offenses can be committed are not expressly set out through these general offenses, that they're more framed around the basic ideas of taking without permission or obtaining through some kind of deception. And though there are in the criminal code a variety of other more specifically framed criminal offenses, I think most charges that we see will fall under the rubric of either theft or fraud. And there can be a substantial amount of overlap between those offenses. So some forms of wrongdoing can be prosecuted as both theft and fraud. And in those particular cases, the Crown may choose to proceed under one or the other, but those would be the main types of offenses that we would see charged in these kinds of cases. Even though there is, for instance, a specific offense of obtaining funds through the misuse of a power of attorney, even that form of conduct can be captured as fraud, because that's a dishonest and unauthorized use of the permission that a person has that would equate to dishonest behavior. So I think that the predominant charges we see in these types of cases are likely fraud, where there is some deception that takes place.
Thank you.
That leads. Yeah.
Sorry, Ms. Kleinberg, we're over time here for Mr. Moore. Hopefully we can continue on this.
Thank you.
With Mr. Kellaway. Please go ahead. You have 6 minutes.
Thank you, Chair, and hello to my colleagues, and hello to the witnesses. An important study, to say the least. My questions are going to be directed toward the officials from Department of Justice, Madam Chair. And first, a comment. The first wave of the COVID-19 pandemic, it highlighted the mistreatment of so many of our seniors living in long-term care. It was devastating to hear stories of the living conditions and treatment of patients. And as Canadians, I think, and I know we're better than that. So my questions are this. Do we have specific data regarding elder abuse in institutional settings? And how does this vary by province?
As I mentioned at the tail end of my remarks, this is one of the areas that we are working on to get a better sense of the data in the broader context, including in the long-term care facility. So we're working with Statistics Canada on that. That said, the committee may wish to consider whether there are some officials from Statistics Canada who may have a bit more information directly germane to that. And the committee may also be aware that a number of studies or commissions have been or are underway or recently concluded in at least Ontario last week, and Quebec has another review underway as well. So that would be a matter that would be beyond our area of responsibility, but there's certainly I think two things. I think there is some data that is available by some of those other bodies. And two, I think we would all agree, though, certainly that the circumstances of the continuing circumstances of the pandemic have highlighted the need to get better data. And that was known even before the pandemic.
Great point on that. So I want to continue with the Department of Justice. So as we work with provinces and territories to improve conditions in long-term care, can you tell the committee if there are any regulatory offenses in the jurisdictions we control for long-term care volunteers that would be beneficial in eliminating elder abuse? And if so, what would that look like? That's for the Department of Justice.
I will take a stab at this, but I just want to make sure I understand your question. You say regulatory offenses in the areas that we control, meaning the Parliament of Canada.
Correct.
Well, I don't know that we in the Department of Justice would be responsible for any such regulatory offenses. Our responsibility really being limited to the criminal code. If that's what you're asking about, I can address that.
Yeah, please do.
Just on the okay, so as far as the criminal code is concerned, again, Ms. Morency mentioned the key offenses in her opening remarks. So if the mistreatment is in the form of unwanted touching, harmful touching, we have a full range of assault offenses that would cover that. But a lot of what we heard and was reported on that took place in long-term care was in the form of neglect. So the failure to protect residents from transmission of disease, failure to provide necessary hydration and nutrition in some circumstances, failure to deal with bed sores or other types of illnesses and injuries. And so the criminal code does contain several offenses. The most important offense would be Section 215 of the criminal code, which is the failure to provide the necessaries of life. That is a duty-based omission type offense, which means that it only applies to persons who have the legal obligation to provide the care, and where they fail to provide the care and that endangers life, that is criminally punishable. So that is an offense that certainly applies in the long-term care context. There's a more general version of a negligence-based offense called criminal negligence causing bodily harm or death. It has a slightly higher criminal law standard. So the behavior must be a marked and substantial departure from the standard of care a reasonable person would use in the circumstances or the context of criminal negligence causing bodily harm or death. And those offenses are also punishable by a higher maximum penalty than the offense of failing to provide the necessaries of life, which has a slightly lower threshold. The departure from the standard of care need only be marked. But they do cover a lot of the same conduct. So you would see charges laid for both offenses in some circumstances. And that would cover both the failure to provide necessary care and also if care is provided, but in a very significantly negligent manner, that could be captured by the criminal negligence offenses as well.
Thank you very much. Madam Chair, how much time do I have?
30 seconds.
Okay, I'm going to try to get one quick question in. A 2009 report prepared by the Department of Justice Canada Family, Children and Youth section noted the legislation using the terms elder abuse or elder neglect are rare internationally outside of the United States. So two quick questions. Is that still the case in 2021? And what are the pros and cons of using such terminology in legislation or in criminal law?
Well, just quickly, I'll just say that report, the 2009 report, actually was used to inform the reforms that were enacted by Parliament in 2012, that sentencing aggravating factor, which looked at the range of circumstances. And my colleagues from Ms. Underwood could also speak to that is one of the things that the government has committed to look at is how do we define and what are the variations in the use of terms within Canada, policy outside of Canada, et cetera. So it continues to be a variant.
Thank you. Thank you very much. We'll now go to Monsieur Fortin for 6 minutes. Please go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chairperson. Madam Chairperson, my question is directed at Ms. Morency. I'd like to hear what you think, Ms. Morency. We have started to talk about the current provisions of the Criminal Code on criminal neglect and the failure to provide the necessities of life, etc. But how do you see the provisions of the Criminal Code as they currently stand in the context of combating elder neglect, be it financial, care-based? How do you see the current provisions vis-à-vis the needs that are felt?
Je vais essayer de répondre.
Well, I'll take a stab at that. Let me say two things right off the bat, and I'll continue in English.
Conduct that arises that involves the mistreatment or abuse of seniors or elderly persons can be addressed in a number of ways. Could be addressed through the Criminal Code if it rises to the standard of some of the offenses that we've described. Conduct that involves treatment or of, for example, persons in long-term care facilities might also be addressed through provincial regulatory oversight. And how things proceed under one or the other may depend upon what is the evidence in a particular case. Could the police proceed more easily under one system than another? And maybe there are different standards that are at play. My colleague Joanne Kleinberg has explained on the failure to provide the necessary life and the standards that are applicable under the Criminal Code. Provinces under their regulatory oversight for long-term care facilities and the rules that are in play there would have different standards. At the end of the day, conduct can be treated sometimes under one or the other. Sometimes in the criminal law context, as my colleague has said, the same conduct might result in charges for a number of offenses, but ultimately it's going to depend on what are the facts and circumstances of each case.
Mais sur le plan du...
Well, as far as the Criminal Code is concerned, I understand that we won't be dealing with provincial areas of jurisdiction here. We're sure about that. But when it comes to federal areas of jurisdiction, it's my understanding. And by the way, I really liked your introductory remarks. Could I have a copy of them, please, if that's possible, if you have no objection? It'd be very helpful. But let me turn back to my question. Now, if we limit ourselves to federal areas of jurisdiction here, in your opinion, are the current provisions in effect in the Criminal Code and elsewhere adequate and up to the task to deal with the situation at hand? Or in your opinion, is it incumbent upon us to amend the current provisions or even enact new legislation or a special section of the Criminal Code? How do you see the lay of the land, of course, specifically sticking to federal areas of jurisdiction?
Chair. Secondly, I think I would just remind the committee that the government has made a commitment to more specifically address the situation by explicitly penalizing the neglect of seniors in these situations. So clearly the government has committed to do more to the extent that something is in place now and there is conduct in question. Certainly there are many offenses that we've highlighted and factors that are available to proceed in the immediate, but on the go-forward basis, the government has clearly indicated that more will be coming.
Okay.
Now, perhaps one of you, I don't know which of you would be best positioned to answer this question, but do you have statistical data currently on the number of cases of elder abuse, either broken down by province? And as an additional question, do you have any data on whether or not there are more crimes of a physical nature or more crimes of an economic or financial nature against seniors? Figures available. Perhaps one of you could fill me in.
Unfortunately, we do not have those statistics, but again, as I mentioned, the committee may wish to reach out to the Canadian Centre for Justice and Community Statistics, Safety Statistics, with Statistics Canada, sorry, they may be able to provide you with more information, but they certainly have released a Jurastat on data of family violence in Canada from 2019. And in there, section 4 deals with some of the factors that you've asked about. But we've also acknowledged in my remarks that we need more and better data in this area. And that's why we're working with our partners to get that.
Now, with which partners are you working with? You say that you need more information on these issues. Is there currently a study underway? Yes, indeed, there is. We are working at the Department of Justice with Statistics Canada. I see. And we're awaiting the next results next year. And what will that data be about? Will it be a breakdown of the various types of elder abuse, be it physical or financial?
Framework to collect better data across the different categories.
Okay.
I see. Well, I'm sure I've almost run out of time, but thank you very much.
Thank you very much, Monsieur Fortin. I appreciate that. We'll now go to Mr. Garrison for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair, and thank you to the witnesses for being with us this morning. I'm going to ask the justice witnesses a question, but I'm going to ask them to bear with me a moment while I lay out a story that I think raises some questions about how we actually respond to elder abuse. The story I want to lay out is of a private for-profit company providing services to seniors, a company that in narrow business terms is very successful. And in 2020, this company exceeded its profit projections by 40%. And as a result, it paid out more than $1 million in bonuses to its top 5 executives, including a bonus of nearly $500,000 for performance to its CEO. Now, what if I tell you that this company is a long-term care company? It had revenues of $716 million from long-term care and operated dozens of long-term care homes in 4 provinces. And this company suffered a rate of death for its residents of about 3.6 per 100 beds. So nearly 4% of the residents in its homes died from COVID. In 2 of those homes, more than 20% of the residents died from COVID. And so I would also point out that in one of those homes, in 1 month, the home was cited for 13 violations of standards of care, including failure to provide adequate hydration, failure to provide incontinence care, and failure to provide adequate nutrition. 13 times in 1 month, while paying out $1 million in bonuses to its chief executives. Now, the question I really have here is, certainly the witnesses laid out that there is criminal negligence causing bodily harm and the failure to provide necessities of life. 2 aspects of the criminal code, which I think clearly apply in these cases, where the company involved, and I don't name the company because unfortunately, you could name, or I could name, at least 4 companies with almost exactly the same story to tell during COVID. Yet I'm unaware of any criminal charges of any sort laid against any operator of a long-term care home when we have had certainly a vast proportion of the COVID deaths taking place in long-term care homes and a large proportion of those taking place in a second wave, which indicates there was a failure to put in place an adequate response plan, which to me would also qualify under Section 215 as a criminal offense in failing to provide necessities of life, which would have required hygiene and infection protection measures, which were not taken in these homes. So my question to the Department of Justice officials is very specific. Have there been any charges laid? And if not, or if there have been only a few charges, who's responsible in our system at this point for charges being laid for criminal negligence or negligence in providing the necessities of life in long-term care homes during COVID?
Thank you for the question. I don't think we are aware of charges having been laid in respect of this or other long-term care circumstances. We are certainly aware of, on the civil side, a number of lawsuits that have been laid both against long-term care facilities and I think against provincial governments. Who is responsible? Well, I think the members of this committee will probably know that law enforcement is a local responsibility. So it would be for the police departments in the jurisdiction where the alleged offenses took place to gather the evidence. Now, we don't know whether that is happening. It may be that there are investigations taking place and but charges haven't been laid yet, or we haven't come to be aware of them yet. There may also be enforcement actions taking place on the provincial regulatory side that we are not aware of. I think that's the most that we could say about that.
But this seems to raise a certain problem for me when the courts have specified that there needs to be action both to deter and to denounce elder abuse. And if we're not seeing these prosecutions, now a year after it became clear that there were failures to provide necessities of life, failures to provide what was really needed, and we have no prosecutions, then there's no denunciation and there's no deterrence. And in fact, what we're seeing now is it's being left to the relatives of those who lost loved ones to bring lawsuits as a kind of deterrent factor. So it seems to me that this raises questions about how seriously we're taking elder abuse. And I'm not sure. This is why I wish to have the ministers present today. I'm not sure that I can ask a public servant to really answer that question. But I am concerned. And I do agree, our system says, well, local law enforcement, but there's something larger happening here that's probably beyond the capacity when it comes to companies who operate in multiple jurisdictions for local police to actually investigate the circumstances.
Madam Chair, if I might just briefly, again, just to note, I think the committee is aware that the government has committed to go further with criminal law response to this. In the meantime, as my colleague has said, we're not in a position to say to the committee that some investigations are or not happening. But if we were to take notice of the report that the Ontario Commission released last Friday, for example, it does speak to many of the issues that the member has raised, including the fact for further investigation and review about how all of these things are playing out individually and collectively, right? Is it a question of timing? I don't know. We're not in a position.
Thank you very much. That concludes your time, Mr. Garrison. We'll now go into our second round of questions. For 5 minutes, Mr. Lewis, you're up first. Please go ahead.
Well, thank you very much, Madam Chair, and thank you to all the witnesses. Very good testimony once again. This is a really important conversation. It's a tough conversation. It's been going on for quite some time, I do believe, but I'm listening very closely to the testimony, and I do have a few questions here, because although it does fall under provincial jurisdiction to a greater extent, this is something that I believe the federal government can help out with. So to any of the panel, what conversations have been had with provincial counterparts on what could better help seniors and what resources are required?
Who was that for, Mr. Lewis?
Anybody on the panel could answer my question, Madam Chair.
So I'll leave it to the witnesses. Ms. Underwood, please go ahead.
Sure, Madam Chair. I think I could talk a little bit about the work that the government has been doing, or that the work that the government is supporting for the Health Standards Organization and the CSA group, who are working together on engaging a broad range of stakeholders across the healthcare system and the public to develop national healthcare standards. So there is work underway around developing better standards in long-term care that will address both the safe delivery, reliable, high-quality services, and health infrastructure and environmental design in long-term care. That work is ongoing, so I can't speak to the specifics as what's happening, but there is work ongoing in that space. Also, I should mention that that the government did commit in the budget 2020 to propose funding for the Public Health Agency of Canada of $50 million over 5 years to design and deliver interventions that promote safe relationships and prevent family violence, including elder abuse. So this is less in the institutional setting and more on the individual space, but I think that's important to include as well.
Thank you, Madam Chair, and sorry for the background noise. So back to Ms. Underwood, what role can the federal government play to support further research on how to best combat elder abuse?
To think the federal government's role, we do need to stay in the space as other members have mentioned today, Madam Chair, including the criminal code being in our federal space, and I'll turn back to Madam Morency for that discussion. Also, I think our role in supporting provinces and territories and looking at the standards that they have in place in their jurisdiction. So as a leadership and support role in that space. Including and other funding to prevent elder abuse, as I mentioned.
Thank you very much. Most Canadians believe elder abuse goes unnoticed, but when it is reported, how often is the abuser actually prosecuted? And what is the success rate for victims of elder abuse in the courts?
Again, unfortunately, we aren't in a position in the Department of Justice to collect that type of data. I do encourage the committee to consider reaching out to Statistics Canada for that. What I can say is when we look at reported case law, we definitely are seeing so it depends. Not all cases that are actually charged and prosecuted ended up being reported as case law. When we look at the reported case law, we do see more cases that occur involving abuse, sexual assault, neglect, fraud than we do on, for example, in a long-term care setting. There have not been very many cases that we've been able to find. So to the extent that it's an excellent question, and definitely there is a strong interest to find out that connection. But I do think that that family violence report that I mentioned to the committee may be, or someone from Statistics Canada may be able to more directly respond to your question.
Thank you very much to all the witnesses, and I guess I'll certainly side with Mr. Garrison on this front. It would have been fantastic to have the minister here to answer our questions, but I do appreciate all the witnesses. Thank you, Madam Chair.
Thank you, Mr. Lewis. I will now go to Mr. Lauzon for 5 minutes. Please go ahead.
Thanks, Madam Chair. I will share my time with my colleague Arif. Now, merci beaucoup tout le monde pour l'invitation.
Thank you very much, everyone, for this invitation to join the committee. This is a crucial committee to my mind, especially with the study of elder abuse. These are very sensitive, delicate issues when we talk about physical, financial elder abuse. Often it's financial in terms of cash, but sometimes those who mistreat our seniors steal their assets, their belongings. There's also psychological and physical abuse. And unfortunately, it's sad to face this fact, but there's also sexual abuse. And this is a highly sensitive issue that I care very much about. But for a number of years, Statistics Canada has been gathering data on elder abuse. Now, there's a GBA analyses which demonstrate that women are, of course, more vulnerable. And do we know which seniors, are there particular age groups, for example, that point to who is most affected and how women are impacted in comparison to men? Perhaps Ms. Morency is best placed to answer that question, or anyone else for that matter.
Thank you. Again, the Family Violence in Canada, a statistical profile 2019 report does provide some of that information by Statistics Canada. As noted, it talks in particular about violence against seniors at the hands of someone known to the victim, but it also gives a little bit of information by way of comparison about stranger violence against seniors. So I do commend that report. I'm happy to provide that report to the committee in English and French. It does provide some of that background. And yes, as noted, women, who's more vulnerable? It can often be, and is often, women are more vulnerable, but it's not only women that suffer elder abuse, senior abuse, and it takes a variety of forms. You know, one of the challenges is getting better data and having it reported, and it's like domestic violence, intimate partner violence. When it occurs in a private setting, it's often difficult for victims to know, can they report, who do they report to, who they can get help from. And that's why the Department of Justice is supporting additional or enhanced materials, public legal education materials for victims or potential victims of elder abuse to help them understand where they can go for help.
Merci beaucoup. Merci pour...
Well, thank you very much for your response. Now, I'd like to leave some time to Arif, but I have a crucial question that I'd like an answer on, if I may. 50 million would be earmarked in the 2021 budget to deal with elder abuse. So what can that money be used on?
So I think, Madam Chair, I think we need to talk to the public health agency specifically on how the money will be distributed. It will support the prevention, or it's intended to support the prevention of abuse in both in relationships, family violence, but also includes elders.
Merci. Allez-y, Arif.
Go ahead, Arif.
Thank you, Mr. Lauzon. Just very briefly, I agree with the problem that's been highlighted by Mr. Garrison that seniors in care have been failed during the course of the pandemic. But I also understand and know that we don't direct law enforcement officials about where and when to lay charges, and that's an important aspect of a democracy. So given that's the context that we are in, and Ms. Morancy, if you could perhaps address this, if we were to be minded to increase the tools that are in the toolbox for the laying of charges, given what's in the speech from the throne where it says explicitly penalizing those who neglect seniors under their care, putting them in danger, Ms. Morancy, do you have any sort of suggestions as to how those improvements could be made to the criminal code? Thanks.
So as and when the government moves forward with its proposals to amend the criminal code in support of that commitment, obviously we would normally, and we would definitely in this particular case, look to work closely with our provincial and territorial counterparts to enhance their understanding of what's being proposed, but also about the tools that exist already in the criminal code. I do think all of us will be informed as well by new information and findings that are coming forth, including, for example, I've mentioned already the report in Ontario from the last Friday, which took like I would say in the moment, a type of a snapshot of what has happened so quickly during the first wave of the pandemic. I do think that as we at the federal, provincial, territorial table move forward to look at this, for us, it's in the criminal code context, criminal law context. I think we definitely would be looking to work with our counterparts to enhance awareness about existing new tools. What can we do to share information more easily with each other? But I do think more will come to the forefront as we progress through and learn about other, even as my colleague has said, there are civil lawsuits at play as well.
Thank you. Thanks very much. That concludes your time, Mr. Virani. We'll now go to Monsieur Fortin for 2.5 minutes. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam Chairperson. Now, Ms. Morancy, in the same vein, from your earlier remarks, I understood that there is a report that will be published by late 2022 on statistics on cases and prevalence of physical, financial and economic elder abuse, but perhaps the current legal framework might be reviewed in light of those figures in due course. But in the meantime, should I understand from your testimony that in your opinion, the prevalence of elder abuse is actually on the rise vis-a-vis what it was 5 to 10 years ago?
That is my understanding from that report as well. The Family Violence in Canada Statistical Profile 2019 did conclude that there has been an increase in the level of violence against seniors, including in the family violence context. Absolutely, we do need better and broader and disaggregated data, and that's part of what we're going to work towards to help us be in a position to better collect that data through Statistics Canada. But in the meantime, there is some data that shows what you've just noted.
OK. Seriez-vous d'accord pour dire...
Do you agree that if cases do rise, generally speaking, that the provinces will be in a bit of a pickle, won't they? Because the federal government, it's its area of jurisdiction, the whole legal aspect of this, but in terms of the care given to seniors, that's often a provincial area of jurisdiction. So there's a bit of a mismatch there. Is it perhaps opportune that we recommend an increase in transfer payments from the federal government to the provinces to, in fact, compensate for these difficulties that seniors are facing?
I'm not sure if my colleague, Ms. Underwood, wants to speak to that, but I would just say, as an official with the Department of Justice, I'm not well positioned to speak to transfer of funds dealing with health.
Well, I just have a couple of seconds left. Ms. Underwood, what are your thoughts, please? No, me either. I really can't. So no one has money here, and it's not of interest to them? Well, this is something that is important to bear in mind. I know that the criminal code is a federal area of jurisdiction, but from what I understand of your testimony, care, which is delivered by the provinces, is also facing in dire straits right now. So we need to help the provinces to deal with this increase in needs. Thank you, Madam Chair, for your indulgence. Thank you, Ms.
Monsieur Fortin. We'll now go to our last questioner for this panel, Mr. Garrison, for 2.5 minutes. Go ahead.
Thank you very much, Madam Chair. I want to stay focused on the crisis in long-term care, which has cost so many thousands of lives. But in doing so, I don't in any way take away from the large problem of the individual cases of elder abuse that take place in our country. But I think we have a responsibility to respond. So I'm going to go back to the question of who could be investigating and who could be working on laying charges in cases which appear to indicate violations of Section 215 of the Criminal Code. And that is when for-profit long-term care companies own homes in more than one province. Would it not be possible for the RCMP to do an investigation into conditions and responses under COVID of those companies because they cross provincial lines of jurisdiction? And I'm thinking in particular of one company, again, which I won't name, which paid $10 million to its shareholders during COVID, but spent only $300,000 on its COVID response plan in its long-term care homes. So isn't there an aspect here that does become federal when these companies cross provincial jurisdiction lines? And I'll ask again to justice officials.
To the justice officials.
I will try to answer, but with apologies and respect for the committee, this is not an area that I think I have tremendous expertise in. But I think our understanding is that the crimes committed in the local jurisdictions are still the matters of the local police, and that they would work cooperatively with local police in other jurisdictions where the same or similar offenses had taken place by the same potential suspect. It's not my understanding, but but I would recommend that perhaps you invite the RCMP to ask them this question. But it's not my understanding that because a crime may cross provincial borders, that would give the RCMP enforcement jurisdiction.
I would use the parallel of organized crime, where there are sometimes special task forces set up by the RCMP to investigate things. And when you look at the case of a long-term care company paying out such huge amounts in dividends to its shareholders and failing to provide the necessities of life to the residents of their care homes, this seems to indicate a gap, I guess, in our system if there's no one who can look at that larger question of whether this in fact constitutes a criminal code violation.
Thank you, Mr. Garrison. Unfortunately, that does conclude your time. And I'll just take a moment now to thank the officials for being here today and for your very compelling testimony and for answering our questions. We'll now suspend for a few minutes as we let in our next panel of witnesses. Thank you again, and see you in a few minutes. and I welcome our new, our next panel of witnesses on and continuing the study on elder abuse. Thank you to the witnesses for being here today. Just a couple of housekeeping items. For witnesses, before speaking, please wait until I recognize you by name. When you are ready to speak, you can click on the microphone icon and activate your mic. When you are finished speaking, please make sure that you go back on mute. All comments should be addressed through the chair. Interpretation is available to you at the bottom of your screen. Please select the globe icon and select the language that you would like to listen to. You can speak in any language, English or French, no problems. When you're speaking, do speak slowly and clearly so that we don't have any problems with interpretation. And I'll remind again, when you're not speaking, just please do be on mute. So I'll welcome our witnesses for this second panel. As an individual, we have Marie Beaulieu, who's the professor and chairholder, research chair on mistreatment of older adults at the University de Sherbrooke. And we also have the Advocacy Center for the Elderly, represented by Mr. Graham Webb, who's a lawyer and executive director. Both of you will have 5 minutes each, and I will keep time with a 1 minute remaining and a 30-second remaining time card to help you along the way. You'll have 5 minutes each. We'll start with Madame Beaulieu. Please go ahead. You have 5 minutes.
Alors, bonjour. Merci de me recevoir.
Well, thank you for inviting me to participate in the work of the Standing Committee on Justice and Human Rights, which is examining a subject that has been close to my heart for nearly 35 years. And I share your concern to fight more effectively against this social and public health problem. I'll try to limit my remarks to the federal government's areas of jurisdiction while clearly advocating for more robust federal, provincial, territorial dialogue, particularly with regard to intervention practices that are the responsibility of the provinces and territories. My presentation is divided into 4 points. First, what is known about abuse? Ample data helps us to paint a picture of elder abuse. And on that note, one of our recently published articles has been sent to you. Annual prevalence rate of elder abuse at home is approximately 16% worldwide. The 3 recent pan-Canadian prevalence studies show a prevalence of just over 8% back home. The takeaway should not be that the situation is better here, as methodological issues contribute to underestimating the magnitude of the problem. A dearth of data makes it impossible to determine the percentage of abuse in long-term care settings. This is a concern given that residents with cognitive or physical limitations are ill-equipped to advocate for themselves. Several studies have focused on the determinants of abuse, and contrary to popular belief, abuse can be explained more by risk factors, i.e. the environment and characteristics of the abuser, than by vulnerability factors specific to the senior, for example, cognitive decline, impairment and low income, even though they are significant vulnerability factors. The many forms of abuse have physical, psychological, material, financial and or social ramifications. We recently completed a research project on abuse of seniors with disabilities that documented the extent of the short and long-term consequences. This is especially troubling given that the abuse occurred in the context of providing services that seniors absolutely needed to function. I see this as related to your concern about specifically cracking down on those who neglect seniors in their care. Finally, it's important to continue to raise public awareness, train current and future practitioners, promote early identification, provide a response adapted to the needs of abused seniors, and so on and so forth. My second point is the legal scope of the concept of abuse. One of the issues your committee is considering is the adequacy of current laws to combat elder abuse. It is important to remember that many forms of abuse cannot be addressed through law enforcement because they are not currently included in the criminal code. Examples include ignoring an older person, inadequate rental lease clauses, the burden of proof to prove criminal harassment is too high, and so on and so forth. Only Section 718.2 of the Canadian Criminal Code, which deals with the principle of sentencing, coherently reflects the link between victimisation age and the upshots of those. Is this enough? Few incidents are reported to the police, who are the gateway to the criminal justice system, and while seniors do not always want situations to be criminalised, especially when the abuser is a loved one, what about police preparedness? During the time set aside for questions, I can talk to you about the practices of the SPVM, the Montreal Police Force, developed through funding from a New Horizons for Seniors program grant, which has been saluted by the World Health Organization. And we also need to discuss telewitnessing, that is remote evidence giving, and the adverse effects of delays. My third point is access to justice. Access to justice has a strong social dimension that presupposes a certain amount of freedom, whereas many abused seniors are under the control of the person or the organisation that is abusing them, which affects their ability to make decisions and to move about. This affects their ability, as I said, to make decisions, and some loved ones who want to protect them instead end up coercing them. Professionals and organisations often engage in abuse themselves, and several studies show that professionals adopt paternalistic attitudes towards seniors and make decisions on their behalf when they should not do so when it comes to engaging the justice system, and sometimes deem them incapable of doing so themselves. So in that context, how can seniors exercise their agency on autonomy to access justice? It's important to put in place free, low-cost structures that can guide and support seniors in their quest for justice. And without this, lack of access to justice only exacerbates inequalities of age, gender and social economic status. Furthermore, I'm convinced that Canada can do more and better in the area of restorative justice. Fourth and final point, Canada's role in promoting the rights of seniors. Since 2016, I've been involved in the work of the UN Open-Ended Working Group on Ageing for the Protection of the Human Rights of Older Persons. I contribute to this not as a university professor, but as a person involved in the NGO, the International Network for Prevention of Elder Abuse. Canada is often seen as a beacon in the world. However, I wonder about Canada's reluctance and at times resistance when it comes... Have I run out of time, Madam Chair?
But thank you, Madame Beaulieu. Maybe the rest of it will come out through questioning. I will now go to the Advocacy Centre for the Elderly. Mr. Webb, you have 5 minutes. Please go ahead.
Thank you. Thank you, Madam Chair. Elder abuse is a very broad topic. We can't say everything we wish to, and I will focus my remarks on elder abuse and neglect in long-term care homes, retirement homes, and other congregate living facilities. Our submissions are, firstly, that we need a new charging section in the criminal code to specifically address this situation. We need whistleblower protection in the criminal code, and we need personal responsibility of directors and officers for criminal sanctions. The Advocacy Centre for the Elderly is a community legal aid clinic established in 1984 that is committed to upholding the rights of low-income seniors. Its purpose is to improve the quality of life of seniors by providing legal services, which include direct client assistance, public legal education, law reform, community development, and community organizing. ACE receives thousands of calls per year, and it provides legal advice and representation to low-income seniors on age-related issues, including long-term care homes, retirement homes, and other congregate living facilities, and elder abuse across a broad range of settings. We are familiar with issues of elder abuse and neglect in care homes, and with the criminal ramifications of elder abuse and neglect in those situations. We will focus today on care homes and the sufficiency of the criminal code to address that. Madam Chair, in answer to a question posed by Monsieur Fortin to Ms. Morency, in our view, the criminal code is not adequate and is not up to the task of a substantive criminal justice response to elder abuse and neglect in care homes. Further to a comment made by Mr. Garrison, we at the Advocacy Centre for the Elderly have called for criminal investigations of neglect in care homes, and we are not aware of any charges laid either. And further to a comment made by Mr. Virani, we think that charges are usually not laid for want of a suitable charging section. Elder abuse and neglect in care homes is a systemic problem that requires a systemic response from the criminal justice system. The criminal code needs to be amended by adding a new charging section that is separate and distinct from failure to provide the necessaries of life and from criminal negligence, both of which offenses speak to duties tending to the preservation of life, but do not sufficiently respond to elder abuse and neglect in care homes. A new offense could be criminal endangerment, which could include the following essential elements. First, that an individual or organization has entered into a contract to provide care and/or supervision to a person. Second, the individual or organization has failed to provide adequate care and/or supervision to that person. And third, the failure to provide adequate care and/or supervision has endangered the health and/or safety of the person. In keeping with a similar crime against a person of failure to provide the necessaries of life under Section 215 of the Criminal Code, a punishment of imprisonment of up to 5 years on conviction by indictment, or of up to 2 years less a day on conviction by summary conviction procedure could be an appropriate range of sentence. As is the case with criminal negligence under Sections 219 to 221 of the Criminal Code, discrete offenses of criminal endangerment causing bodily harm and criminal endangerment causing death could be created with similar penalties of imprisonment of up to 10 years for criminal endangerment causing bodily harm and of life imprisonment for criminal endangerment causing death. These proposals represent serious offenses with serious consequences that reflect the severe vulnerability of the victims, the position of trust held by care providers, and the profound power imbalances that exist between those who provide care and those who receive it. The Criminal Code should also protect whistleblowers by creating a separate and distinct offense in the nature of a crime against the administration of justice for an individual or organization to retaliate against a resident of a care home for making complaints concerning criminal endangerment or other aspects of failure to provide adequate care and supervision. A similar offense is found in sections 139, subs 2 and 3 of the Criminal Code in respect of obstruction of justice and the intimidation or interference with witnesses in an existing or proposed judicial proceeding.
Thank you, Mr. Webb. We are over time. We'll go into our round of questions, the first round being 6 minutes each, starting with Mr. Cooper. Please go ahead, sir.
Thank you, Madam Chair, and thank you to the witnesses. I'll first begin with Mr. Webb and perhaps let him continue where he finished off. The Criminal Code obviously is within the exclusive domain of Parliament, so I'm very interested in recommendations on current provisions in the Criminal Code, where there are gaps and how those gaps can be closed. And Mr. Webb, you were talking about whistleblower protection. I'll allow you to elaborate further on that and also touch upon the third point that you raised but didn't have an opportunity to address in your testimony, namely personal responsibility for officers and directors with the imposition of criminal sanctions under the code.
Thank you, Mr. Cooper. I very much appreciate that, because without strong whistleblower protection, there will be no existing or proposed judicial proceedings, because complaints will not be made and charges will not be laid. Many older adults are afraid to make complaints about inadequate care because they fear retaliation from their caregivers. Any criminal offenses concerning failure to provide adequate care and supervision would be meaningless in the absence of strong whistleblower protections that would give care home residents, their families, their substitute decision makers, their friends, and other loved ones assurances that interference with their right to make complaints will be respected and upheld. The criminal responsibility should extend not just to individuals and organizations in general, but specifically to those who own, govern, and operate care homes. One of the many difficulties in prosecuting offenses such as failure to provide the necessaries of life and criminal negligence causing death or bodily harm is identifying which, if any, of the individuals associated with the operation of a home should be held personally responsible for criminal sanctions, where the home has profoundly failed to provide adequate care that has endangered a person's health and safety, even to the point of bodily harm or death. Those who own, govern, and operate care homes are fundamentally responsible for committing resources, setting budgets, establishing operating procedures, recruiting and maintaining adequate staff, and ensuring that enough well-qualified staff are on site at all times to provide essential care. If a home is not managed properly, it's foreseeable that registered staff such as nurses, social workers, occupational therapists, and unregistered staff such as personal support workers will be placed in highly compromised situations in which they are completely unable to provide the care that's needed for want of adequate resources. Responsibility for the overall operation of the home rests at the highest levels of ownership, governance, and management. Those occupying these positions should have personal criminal responsibility for ensuring with compliance with the Criminal Code of Canada in respect of the caregiving functions of the home. Otherwise, a systemic criminal justice response would not be provided to a systemic issue of elder abuse and neglect. And finally, in view of the fact that elder abuse and neglect in long-term care homes, retirement homes, and other congregate living facilities is a systemic issue that largely derives from inadequate resources and poor management of a home, it would be fit and just to extend liability for custodial sentences to the owners, governors, and operators who are in a position to provide the systemic responses that are necessary for the good and safe operation of the home. I thank you for allowing me the extended time.
Thank you, Mr. Webb. Now, with regards to the first suggestion of a criminal endangerment section, are there any other sections you could point to in the criminal code that are analogous, or is there other jurisdictions that have adopted a law such as this that we could look to?
Well, if I can focus my remarks on Canada and Ontario, I've practiced law in Ontario for 36 years, 25 years with the 26 years with the Advocacy Centre for the Elderly. There are analogous sections. Section 215, failure to provide the necessaries of life, and sections 221 and following, criminal negligence causing death and bodily harm. These are very difficult charges to prosecute in the long-term care situation, mainly because the the legal liability standard for criminal negligence involves causation, which is difficult to prove. And in any event, when it's an act of omission, it's hard to identify which particular individuals are responsible for the omissions, the care that was not provided.
Okay, thank you for that, and it looks like my time is about to expire, but I will just very quickly ask Madame Bellew, I'm sorry for mispronouncing your name, you had cited gaps in the code. Is there anything you would like to highlight?
Well, listen, I've been concerned since amendments were made to 718.2. It is a reminder and not an obligation to factor in consequences on victims. I don't think we go far enough. And as I said earlier, for me, it's crucial that we address not only the content of the criminal code, but also enforcement, because in cases of elder abuse, there are few cases where police file complaints and these individuals are brought to justice.
Thank you very much. We'll now go to our second questioner, that is Madame Brière, for 6 minutes. Please go ahead.
Thank you, Madam Chair, and thank you for all our witnesses for being with us today. Mes questions sont pour Madame.
My questions are for Ms. Beaulieu. It's a tremendous pleasure to have you with us here today. You know, I sat for over 10 years on the Ethics Committee of the Geriatrics Institute, and I have focused on the protection of seniors' rights throughout my career. This topic of this study is therefore crucial to my eyes and also very worrisome. Now, you just responded to Mr. Cooper regarding policing. Your research has demonstrated that there are few cases that are reported to the police. And just to link up with what you said in your opening remarks, the SPVM police programs, please, could you speak to that? Yes, thank you very much, Ms. Brière. To me, the gateway to the criminal justice system is what is reported to police officers. And what we've seen over the years, up to 5-6 years ago, police officers weren't even trained to recognise elder abuse. And at the New Horizons program meeting, I had an opportunity to talk about EPUM, which is a training course for police officers from the Montreal Police. And I won't hide the fact that police officers, in many cases, had never even heard of elder abuse. And I'll speak mostly about Quebec. I also sit on the Training and Education Committee for the National Quebec Policing School. And now I can tell you that it is mandatory to have training so that police officers can better help seniors. And many young police officers who are in the 20s have no idea about what seniors' abuse is. So sometimes their attitudes towards seniors are ageist, and they have difficulty recognizing that intimate partner violence can even exist in the context of seniors. So first and foremost, we need to build awareness among police officers and also have champions or advocates, police officers who are specifically trained to provide psychosocial follow-up. And we acknowledge the fact that not all police officers bring these cases before the courts, but when it is suggested to them that they accompany seniors to the courts, many agree and they want justice to be served. For many, it's not about enforcing the criminal code to its greatest extent. There are many options. When it comes to alternative and restorative justice, where restoration is the key issue. Unfortunately, a lot of seniors don't want to go before the courts because of the long delays and also because of testimony. There was a highly mediatized case in Montreal and where the individual concerned died just a couple of days after his or her court appearance, perhaps because of the significant stress. So this brings me to the issue of tele-witnessing or providing evidence remotely. That's another issue to consider. We've done this for children and victims of other kinds of crimes. Thank you very much. It's highly, highly interesting what you're discussing. I'd now like to turn to the definition of seniors' abuse. We know that there is no definition in the criminal code, as it turns out, and in a specialized review, NPG, you wrote that abuse was too broad a term. So how would you define seniors' abuse? What are the right words that we should be using to describe it? Well, it took me time to come up with a definition for seniors' abuse. It occurred in 2002 with the World Health Organization. It occurred in Canada, in fact. It was the Toronto Declaration or Statement. And under that definition, it means that there is a single or a repeated action or gesture made by, in respect of the senior person, by a person who would normally have their confidence. This is merely theoretical, but we need to hone in on the whole idea of violence. And one thing that's being debated when it comes to this definition is this relationship of confidence, because it excludes all forms of victimization against seniors. Now, when it comes to a context of confidence, Well, there's, of course, family relationships. Service providers have relationships with family members, and we should be able to place our trust in all of those people. Thank you very much. And in closing, is there a parallel to be made between bullying or intimidation and abuse, because it's a rampant problem? Yes, indeed, seniors bullying was only recognised a couple of years ago, and now we acknowledge that when it comes to bullying, there's a whole power issue here at play, and unfortunately that can be including other seniors as well. Thank you very much. Highly appreciated.
Thank you very much, Madame Brière. We'll now go to Monsieur Fortin for 6 minutes. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam Chairperson. And thank you, Ms. Beaulieu, for being here. And Mr. Webb, we're grateful for your attendance to hear your expert opinions on such a crucial issue. Ms. Beaulieu, I'll start with you, if I may. Earlier in your introductory remarks, you were going to explain 4 different aspects, and you didn't have time to read the final one. I'd like to give you 2 of my 6 minutes for you to provide a summary of the final point that you wanted to address in your remarks. Well, thank you very much, Mr. Fortin. Well, in my first point, I discussed what is known currently about abuse. And then, in my second point, I addressed the legal scope of the concept of abuse. And I referred to the current limitations of the criminal code and practices. Third point was on access to justice. And I drew a parallel with what Mr. Webb said. There is no similar centre across Canada, and I think that's crucial when it comes to access to justice. The fourth point that I wasn't able to elaborate on is Canada's role in promoting the rights of seniors. And I spoke about the work of the United Nations, which is currently working on protecting the fundamental rights of seniors. And in March 2021, Canada sent what I believe was a surprising message, to say the least. Our ambassador to the UN, the Honourable Robert Ray, made a strong statement in support of a convention for seniors. And a couple of days later, a Canadian government representative gave a speech that I would categorise as lukewarm, and in this regard. And I'm surprised that Canada doesn't want to be a leader in terms of the recognition of the rights of seniors. And I'm asking myself, is the Government of Canada afraid of a new binding tool like an international convention? Wouldn't it be a great way of being part of a movement to make ongoing progress in this domain? Well, thank you very much, Ms. Beaulieu. Very enlightening. You said that a centre like Mr. Webb's doesn't exist in every province. And in Quebec, it's my understanding that there is no such centre. Is that what you're saying? Well, there is a centre which provides legal assistance at McGill University, which is run by a lawyer. But in Quebec, they're mostly paid services that aren't always tailored to seniors. It's a model that I've admired for many years, and I've known about this clinic in Ontario for a good number of years. Question: what of the funding of seniors' services? In light of your experience, is the current state of affairs acceptable? Is it ideal? Or is it nonsensical, inadequate? When you talked about funding services earlier, you talked about access to justice, which is crucial to everyone, and probably especially if you're a senior. And then there's physical abuse and such crimes, and also coercive economic and financial abuse. But when it comes to funding services for seniors, and bearing in mind all those aspects I just described, in Canada and specifically in Quebec, are we doing well or are we lacking? Response: well, I think that we are still lacking. When I work with seniors who've experienced seniors abuse. Many don't know who to blow the whistle, where to blow the whistle, who to report to, either because the services don't exist or because they haven't been publicised. There are some community organisations that specialise in senior support for seniors. In the Eastern Townships, we have a centre that works on elder abuse, but it doesn't. That kind of centre doesn't exist across Quebec. And of course, there's a bottleneck when it comes to those services and all the challenges that are as a result of that. I think we're speaking much, much more about elders abuse than when I started to look into the topic 35 years ago, but we're still not talking about it enough. And we need to enhance our practices, especially those services where, for example, the police, community organisations, health and social services centres work together. We can't just have one stakeholder that is responsible for this complicated issue. Question: is the current situation comparable to what we saw 10 years ago, or is seniors abuse on the rise? Or is it just about at the same level, but we're more aware of it because of media and social media? So what's your take on how seniors abuse has evolved over the years? Well, it's just because we talk about it more, we know what it looks like, what it's about, and does that mean that there are more cases in homes or more cases in congregate living settings or institutional settings? What I can tell you is that, yes, in the context of the pandemic, there's been an exacerbation. For some problems that already existed, but we've really shed the spotlight on them, haven't we? Question: has there been a rise in economic elders abuse? For example, earlier you talked about abusive clauses in lease and rental agreements. Or is there, for example, a rise in physical abuse? For example, a grandchild who might abuse a senior. Well, elder abuse includes financial, material, physical, sexual, violation of rights. There's a whole host of factors. And in most of the prevalence studies, it's psychological mistreatment and abuse which is worst, which is often tied to neglect and financial abuse. That's what's most prominent, but that's not what gets to go before the courts, because proving psychological abuse is difficult in the court. Thank you very much. If I have a second left, may I just didn't receive the document.
Over time, so you're almost at an extra minute.
I'll come back to that then. Thank you.
Mr. Garrison, you have 6 minutes. Please go ahead.
Thank you very much, Madam Chair, and thank you to both the witnesses for their very valuable testimony this morning. I want to start with a quick question to Madame Beaulieu. She raised the importance of acknowledging intimate partner violence exists among seniors, and I thank her for doing so, and I know she's probably aware of the work that our committee has done on that. But she also raises another very important question about the ability of seniors, especially in private long-term care homes, to advocate for themselves due to their circumstances and fear of retaliation. And I wonder if she sees a solution to that problem that she could suggest to us, in particular in the case of private long-term care homes.
Merci, Monsieur Garrison, pour votre question.
Thank you very much, Mr. Garrison, for your question. Well, when it comes to institutional settings, well, that has been a problem for a number of years, but I'll be very careful when I speak here. There have been very serious seniors abuse in public sectors as well as in the private sector. But having said that, it is in congregate living settings where seniors are least well equipped to advocate for their own rights because of cognitive decline or physical limitations, and that's why there should be mandatory reporting in the case of seniors abuse. And the majority of provinces have such legislation when it comes to mandatory reporting, but it's not in the criminal code. It has to do with social and health services. Now, that kind of mandatory reporting will, of course, protect those who blow the whistle. And my colleague, Mr. Webb, referred to whistleblower protection as well. Now, oftentimes, it's families that have to blow the whistle, and often they don't know what the proper structures are. There might be a local body or authority that they have to report to, but those are not well known. But those are the kinds of mechanisms that are there that do make reporting possible. But oftentimes these cases don't end up in the courts. So there's a whole array of ways of addressing this issue aside from just the criminal code.
Thank you very much, Madam Beaulieu. I want to turn to Mr. Webb and thank him for his very specific suggestions of things we should be considering. I am particularly interested in his suggestion that we find ways to hold accountable those who are responsible for the decisions, especially in private long-term care homes. And I know in 2020, again, two particularly egregious cases in homes that had very high levels of death. The CEO in one case received a bonus of $467,000 for his performance, and then another a bonus of $336,375. And in both cases, the companies, when reporting these bonuses, made the point that these, of course, could have been higher. I just find this shameful. But I want to ask Mr. Webb about specifically whether the parallels he sees in the criminal code elsewhere, does he really think these can be used to get at this question in terms of responsibility for the failure to provide necessities of life during COVID?
I do, Mr. Garrison, and the criminal law responses must attach responsibility for custodial sentences as well as fines, which may represent simply the cost of doing business. On a matter of provincial jurisdiction in Ontario, the Long-Term Care Homes Act affixes specific responsibility to directors and officers of licensees of long-term care homes to ensure compliance with the Long-Term Care Homes Act. And it also allows a court to impose a fine of up to $2,000 on an officer or director of a nonprofit licensee, or a fine in all other cases for nonprofits, a fine of up to $100,000 for a first offense, and of up to $200,000 for each subsequent offense for breaches of the Ontario Long-Term Care Homes Act. Despite that, we continue to see egregious breaches of the Long-Term Care Homes Act without charges and really without acceptance of responsibility on the part of long-term care homes operators. If Parliament of Canada were to adopt a specific criminal charging section that includes specific responsibilities for officers and directors, that includes potential liability for custodial sentences, we think this would change the picture completely. Bernie Madoff has gone to jail for financial offenses, but we don't see anybody being prosecuted, let alone facing the prospect of going to jail for neglect that has caused the injury and death of thousands of long-term care home residents. You're muted, Mr. Garrison.
Without touching anything, I went to mute, sorry. In your advocacy work here, I know you stated it before, but just very quickly, I haven't found any evidence of not of charges, but of systematic investigations of the homes that were responsible for very large numbers of deaths. And I just want to ask you again, if you've seen any evidence even of investigations of the homes that were the most egregious violator of standards and had the highest level of deaths.
No, Mr. Garrison, this week I'm dealing with a caller whose family member was injured in a long-term care home and has asked the police for an investigation under Section 215 of the Criminal Code, and no investigation has been undertaken. And in the 26 years at the Advocacy Center for the Elderly, 21 years as a staff litigation lawyer, I have routinely written to the Chief of Police or the detachment commander asking for investigations that have only been conducted mainly grudgingly. Sometimes we get investigations and charges on financial matters, but never on caregiving issues in long-term care homes and other care facilities.
Thank you very much, Mr. Webb, Mr. Garrison. We'll now go to our second round of questions for 5 minutes. Madame Findlay, you're up. Please go ahead.
Thank you, Madam Chair, and to Mr. Webb and Madame Beaulieu, thank you both for being here and for your advocacy. for the elderly. Very much appreciated. But it sounds to me like you both often suffer from feeling like you're blowing into the wind. So I applaud you for your for sticking at it for those who are very vulnerable for as long as you have. The Minister of Justice's December 2019 mandate letter noted as a top priority, quote, work with the Minister of Seniors to create a national definition of elder abuse, invest in better data collection and law enforcement related to elder abuse, and establish new offenses and penalties in the criminal code related to elder abuse, end quote. That was reaffirmed again in January 2021 mandate letter. So I think the intention is there and it is clear. The question is it happening? And what could the Minister of Justice do to deliver on that mandate? I think you've been very specific, Mr. Webb, and I thank you for that. It seems to me, though, some of the problems here are also with the prosecution, not just that we may need, and I hear what you're saying on whistleblower protection and new charging sections. That makes sense to me. But I have had my own experiences in this realm where a senior was returned to the care of those who would look after her, having been virtually kidnapped by a son, and then all her money taken away. And it was reported to police, their elder abuse section, RCMP in this case, and they basically took the position, well, you've got her back, she's okay now, the family has her back, so we're just not going to pursue this. And I think what happens often is a great reluctance, because not just the victims, but often the witnesses to the victimization are themselves elderly, and the police feel they can't prosecute on the basis of that evidence, which may be very vulnerable to a rigorous cross-examination or whatever. So Madame Beaulieu mentioning that someone should go with an elder who's been a victim or with them if they're testifying or witnessing makes a lot of sense to me. With this definition, it seems to me if we had a better definition, we would have a more heightened awareness of what elder abuse actually is and what it looks like. Perhaps, Mr. Webb, you could comment on that, defining it. I know Madame Beaulieu has already talked about that.
Well, Ms. Finley, I think it's important to have a clear definition of elder abuse. I think that helps the process. I'm not sure really where it would fit into the criminal code because there is no charging section of elder abuse. It may be important for sentencing purposes. But the problem, as you've identified, is the investigation and the prosecution of crimes to begin with, and to obtain a conviction before we get to the sentencing aspect. And as Mr. Garrison had asked, are the police missing a tool? I think they are missing a tool. They need a specific tool to investigate these crimes. And the situation you described regarding police investigations is chronic. We expect to hear that this is a civil matter because the police feel that they're incapable of investigating on a criminal basis.
So would you agree with me that if we could look to changes in the criminal code, and you've made suggestions on that, we also need to look at a definition within that grouping of changes?
If there were a charging section dealing specifically with elder abuse, then yes, it would be very important to have that definition. And I agree with you that we need also resources and policies on enforcement as well. In other words, for investigations and so on. A charging section is simply the starting point from which everything else flows.
Mr. Webb, I'm interested in the types of claims your organization most often deals with and how, if at all, the types of claims have shifted since March 2020.
We're seeing more and more instances of abuse. The question is it increasing? It is indeed in all aspects. It's a torrent. And, normally we refer issues of physical violence to the police. We're not an investigative agency, we're lawyers. The types of claims that we typically prosecute are civil claims of financial abuse, but they can be accompanied by physical abuse, sexual abuse, emotional abuse, because all forms of abuse overlap. We have provided criminal representation to victims and witnesses, as well as to older adults who are charged with crimes.
Thank you very much. We'll now go to
Thank you.
Thanks, Mr. Maloney, for 5 minutes. Go ahead, sir.
Thanks, Madam Chair, and thank you to both of our witnesses. Very informative discussion. I'm trying to reconcile sort of the two different points of view. Well, maybe they're not two different points of view here, but things that both of you have said. I mean, on the one hand, we're trying to devise some ideas and perhaps amendments to the criminal code that's going to help reduce and prevent and punish those who are guilty of elder abuse. But I'm struggling a little bit with what specific element or what specific additions to the criminal code could be made that aren't that are specific to seniors, I guess is what I'm trying to say. Because Mr. Webb, for example, you keep referring to a charging section. I think it might be helpful if you define what a charging section is to those of us who may not be intimately familiar with that terminology, and then provide us and then let me know whether you have any language that you would like to see in the criminal code in that regard.
Mr. Maloney, a charging section is a section of the code that identifies an offense such as failure to provide the necessaries of life. When I did criminal defense work, the first thing I would do would be to obtain a copy of the information which lays out the charge, and I would open my criminal code on my desk and compare the charge laid to the charging section in the code to make sure it's a valid charge, and often it was not. And so with respect to endangerment, criminal endangerment, I would suggest essential elements along the lines of an individual or organization has entered into a contract to provide care and or supervision to a person, that the individual or organization has failed to provide adequate care and or supervision to the person, and the failure to provide adequate care and or supervision has endangered the health or safety of the person. Those are the essential elements I would be looking at. And by the way, elder abuse is a very broad topic, and I have much more to say as my agency on other aspects of elder abuse. Today, we've come to focus specifically on criminal responses to abuse and neglect in long-term care homes, retirement homes, and other congregate living situations across the country.
Okay, so those suggestions you just made, I'm assuming you wouldn't be putting age restrictions in the law, because
No.
I mean those. Okay, because that's my concern is these issues you're talking about could equally apply to somebody who's 50 years old or somebody who's 70 years old, depending on their circumstances.
We don't think it's appropriate to ghettoize older adults. They have the same rights as all other adults, and the problem is that they are often infantilized and treated as less than a full capable person.
Okay, so what you're really talking about is creating a set of laws that are going to benefit elders and make it easier to prosecute those who are committing acts of elder abuse, as opposed to specifically enunciating laws that deal exclusively with elders. Is that fair?
That's correct, and that's consistent with most of our positions.
Okay, so then it becomes a challenge of trying to enforce these laws and get them reported and get police to deal with them. And I think that's what Ms. Beaulieu was talking about, was that there's really an educational component to this thing, because, and I think it was you that said a lot of the victims here are under the care of others, and it's those people who are the ones that are spokespeople. So that creates a challenge unto itself. So do you have a specific list of recommendations you could provide us with, and how you could, what we could recommend in terms of education for police forces or other authorities to try to provide them with more information that would make it easier for them to understand and better enforce the rules that do exist or any new laws that do come into place?
Mr. Maloney, that's a very broad topic that largely falls outside the area of federal jurisdiction. I can't provide you with specific recommendations today. I can tell you that in the course of our work, we have provided instruction to Toronto police officers at the Ontario Police College.
Sorry, Mr. I don't mean to interrupt, but I'm running out of time. My question was actually posed to Ms. Beaulieu, and I was not suggesting in any way that instructions be given to police. What I'm talking about is an educational component that would help the people who are making these decisions and who are dealing with this on a day-to-day basis to do their job and accomplish some of the goals we're talking about.
You're out of time, Mr. Maloney, so perhaps I can suggest if Ms. Beaulieu, if you would like to provide an answer in writing, that is your prerogative. We'll now go to Monsieur Fortin for 2.5 minutes. Please go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chairperson. I'd just like to continue with what you were saying, Madam Chair. Ms. Beaulieu referred to a document that she said she sent. I believe that the clerk's going to send it to us, but I just want to make sure that that is going to occur, because these are highly complex issues that are of utmost importance. Now, Mr. Webb, let me turn to you. I confess that my colleague, Mr. Mulroney, kind of covered the list of questions that I was about to ask you in my second round. But that said, I understand from your testimony that the whole issue of elders' abuse is sufficiently complicated that there be a separate section of the criminal code that could, for example, define the various types of mistreatment and abuse, define what abuse is in and of itself, and set out a number of specific rules for cases of abuse against seniors. Is that what you were saying, sir?
No, I'm sorry, Monsieur Fortin, that's not my testimony. I'm speaking specifically to specifically an offense that should be created for neglect and abuse in care facilities that would apply to persons of all ages. I'm not speaking of a specific elder abuse provision. I'm speaking of an abuse and neglect provision.
OK. Alors, à ce moment-là,
well, don't you believe then that the same reasoning would apply to all seniors who experience elders' abuse and not just those in long-term care facilities? If I understood Ms. Beaulieu's testimony, it's my sense that there are cases of elder abuse across the board. For example, seniors who live with their families, also seniors who live in congregate living settings, also in financial institutions, also people who live in the streets. Across the board, there are seniors that are experiencing elder abuse that are separate and distinct from other kinds of abuse. Does this not apply across the board to all seniors, Mr. Webb?
I agree entirely, Mr. Fortin, with that comment. Yes, it does. There are many, many different types of situations of elder abuse, and they each deserve a systemic response.
Thank you.
Merci, Madame la Présidente.
Thank you, Madam Chairperson.
Mr. Garrison, please go ahead for 2.5 minutes.
Thank you very much, Madam Chair. And as we draw to a close here, I too want to thank both our witnesses today for their long advocacy on behalf of seniors. And my final question to Madam Beaulieu will deal with another systemic question dealing with access to long-term care, which I've been focused on today. And I know that's not necessarily her sole focus. But we seem to have a situation in this country where those who need long-term care, both the individuals and their families, have differential access. And quite often racialized communities, Indigenous communities, and the lesbian, gay, bisexual, and transgender communities have difficulty finding access to long-term care, which is culturally appropriate and supportive. And so in your work, Madame Beaulieu, have you found this to be the case, that there is a real differential access to necessary long-term care depending on who you are in Canada?
Merci, Monsieur Garrison.
Well, thank you very much, Mr. Garrison. In fact, you've turned my attention to two complementary issues: access to long-term care and also the whole issue of recognizing minorities among seniors. Seniors aren't a homogenous group. On the contrary, there's a whole slew of differences in terms of gender, age group, 60 through to 100, and in terms of ethno-cultural communities, LGBTQ racialized groups, Indigenous. We know that when it comes to gay and lesbians, for example, they have come out and they're open members of the community, but when it comes time for them to enter long-term care facilities, they end up hiding their sexual orientation or gender orientation because in fear of being discriminated against. Now, in terms of access, we know that it is highly limited. It's on the basis of health and social care evaluations. So there's a criteria of eligibility list, and of course there's not enough care to meet the needs of seniors currently. I could have said much more, but I'm going to stop there. But you've opened up two passionate subjects of interest to me.
Thank you very much. I'd love to pursue those further today, but I see that we're out of time. So thanks once again.
Thank you very much, Mr. Garrison. I'll take the opportunity now on behalf of all committee members to thank our witnesses that have come here today with your very compelling testimony. We really appreciate your contributions. And we'll say goodbye to you. And just very quickly to committee members, I just wanted to touch on and give a response to Mr. Garrison's earlier inquiry about invitations to ministers on this. So to our witnesses, you're welcome to leave at this time if you'd like. Mr. Garrison, I did look into the precedent and also into the witness lists and also the notes from the subcommittee. And I have realized that in our subcommittee meetings, we only discussed the presence of and invitations to officials and not to ministers, specifically for this study. And when the witness list was circulated to members, the ministers were also not included by any party on the compiled witness list as well. And I did check precedents as to kind of how we operate in the past, and I realized that it's only with government legislation where we have the minister, on we invite the minister to that first meeting when we have government legislation before us. And I also did look to see what our procedure was with our last study that we did, which was the coercive conduct study. And I noticed that we didn't invite ministers; we only had the department officials. So that's kind of the framework within which we are entering this study. And just to address the question as to why ministers were not invited, it's because they were not on any of the witness lists from any members as well. So I just thought I would give you that update. If there are any questions or concerns at this time, please do raise your hand. Okay, not seeing any in that case, we will now adjourn the meeting. Thanks, everyone.